We are live.
All right, welcome back to the House Judiciary Committee this Wednesday afternoon, April 8th, continuing our work on S-193, an act relating to establishing a forensic facility. And we're going to hear from the Attorney General's office. And Dominica, thank you for being here.
My battery saver has just gone on, so click in. Thank you. For the record, Dominica Padula, Chief of the Criminal Division for the Vermont Attorney General's Office. Thank you for having me here. Thank you for taking up this bill, which is the discussion of competency restoration and forensic facility within Vermont. I came here earlier to hear Jared testify. I had been working with him on those edits, so understanding that you do not have those edits. So I'm going to just talk a bit broadly about it and then just be open to questions to not waste anyone's time on this lovely day. Vermont, as you heard, needs an answer to this question. As Jared testified, it's not an if you build it, they will come scenario. It is here. It is an acute problem. There is a gap. And talking about the forensic facility, which would include both competency restoration services, as well as an end result of an NGRI. It is always difficult to talk about them at the same time because they're such two distinct concepts. And I always appreciate the nuance that you all have of that. That one is the very foundational requirement in order to enter and engage with the process. It is a compelled examination, it's a compelled thing, it's necessary. NGRI and raising that is something that is fundamentally a defendant's right to do so. I can't invoke that for them. I can't say that in my prosecution, and a defense attorney can't say that on behalf of their client. And that is something that they're willingly engaging in that process to address the criminal behavior or the charge that has been brought. So they are very distinct things. In the competency restoration piece, and I do think it can't be overstated that just because someone is dealing with a mental health issue or some kind of condition in which there is an intellectual disability does not make that person any more of a threat to anybody else. It doesn't make them any dangerous to anybody else. Just like any one of us in any category that people like to categorize us all in, we can engage with behavior that makes it so that we might have a criminal charge that is against us. It is not anything that's predispositional. And I just want to start that out to make sure that that is very clear. But for that subsection that does have those issues and does find themselves with facing a criminal charge, we do not do a service to them to not help them engage in the process in which every other person could. If I didn't have those issues, if I didn't have a competency claim against me, I can engage with that service very quickly. We can move forward with the process of me and proving their innocence and proving their guilt, and they can engage in helping to defend their innocence. Those things can happen, and they can happen, I say quickly, knowing that we all deal with the backlogs. We all know that that's probably the one big gripe of everything about how long everything takes. But that process is something that they can enter and engage. When we deal with people who do not have the ability to do that right away, and they have been deemed incompetent to do so, we give them zero tools to help remedy that situation. And that is unacceptable. It means that cases linger, support services that they may need aren't happening. We have victims and other things that are going on, that things just end. And all we do is sit there and wait. This bill doesn't change that for everybody, but it does change it for a very specific subset of that population that we have even less tools in the toolbox. It's one thing when you have competency pending and you have stolen something from the local store. yes, there is harm that happens there, and yes, that those things should be addressed. But it's very different than if you have been accused of killing another person or something in terms where we talk about those life offenses. So those are the cases that, I wish it can be all, but I totally understand that we have to take this one step at a time, and that this is a first good step to figure out what that looks like in Vermont, and what that looks like for our cases. So I do think that this is a really great step, talking about when you do have that, what are the things that we can use to help get you back to a baseline where you can engage with the process from the very most fundamental stages of what this was. And Jared went over those earlier. And that you can be incompetent for a number of reasons, and the remedy to those things are myriad. But that we can at least begin to have those conversations. What currently happens now, especially in these kind of homicide cases that have those things where there may be an untreated mental health condition, that when you are now in DOC custody or within a hospitalization order, those medications and those kinds of services that address an underlying medical condition are met, and that naturally will then set somebody up to be able to engage in that process, and competency will be restored naturally under those conditions. That's not always what can happen, but that's generally what's happening now. And so that's kind of where we have seen ourselves now. It's not intentional. It is just a byproduct of being treated the way someone should have been treated, for however long they should have been diagnosed that way. So that's kind of in that bucket and that space, is that this would be an intentional program to help aid that, plus the underlying medical. And I know, a lot of the tension, a lot of the reasons why, talking about the orders of hospitalization and kind of what that happens. I think it's also really important, another nuance of this area, is that when we talk about competency and we talk about an NGRI, we're talking about legal constructs that aren't medical, but the medical diagnoses can inform those decisions and can kind of tick those boxes about what qualifies for those things or what may not. So that's where we go, where, you can have different opinions. And when a court orders an evaluation, or when we go for an expert opinion, all they're saying is it is in their opinion that this is what's happening. The court determines what is or is not as a finder of fact. Is it competent? Is it not? And again, a jury or a judge could also determine in an NGRI, was that something that rose to that level or did not? So even though these are medical opinions sometimes, or definitely professional opinions about diagnoses and things that are happening, they are opinions, and that they're trying to fit an opinion into a legal construct, which is why it's just not a foregone conclusion. If a doctor says this, then it should be this, because it's much more nuanced and context than that. And it breathes more in a courtroom about what those are. So it feels like those should equal each other, and they don't. And it gets very frustrating when that happens, which is why you can have multiple professionals have multiple opinions about what it is. We see that the most when, they may, two professionals might agree on an opinion, but they won't agree on the reason why. Someone will say it's schizophrenia. Someone will say it's bipolar depression. And it could be both. It could be neither, but that they both agree that, certain other elements from that, flowing from that, mean that they can't comprehend something, or they can't do that. So it really does come down to the information that is given to the finder of fact, and then they work with that information and with the laws of evidence and all of these other things, that they make those really nuanced determinations. So it would be very helpful to have a very specific professional say, this is competency restoration, this is what I'm doing, this is what I did to support that, instead of just trying to get someone to baseline, treat an underlying medical condition, and see if that shakes out in the way it should. So that's kind of the competency piece of that. The NGRI piece is very similar in the sense where, again, as I said, these are opinions. It goes to a jury. It is one of the very few places where the burden shifts. And it's very important, and I know that Jared covered this before, is it says acquittal, but it's not the same as an acquittal. An acquittal means I haven't proven my burden. I have not given you beyond a reasonable doubt of this. And you rightly walk out of the courtroom like it never happened, it's done. And with an NGRI, that's not the same thing that happens. I must prove beyond a reasonable doubt that you have committed this crime. I'll just use homicide because that's basically what we're talking about. And at that point, my job is done as terms of what my burden is, and it shifts to the defense. And then they must make a case for this insanity piece. And that's given to the jury separately after they come to that first conclusion, which is why you can have somebody raise an NGRI and it might never get to that decision point. Because if I haven't proven my case beyond a reasonable doubt, it doesn't matter that they've claimed that during the trial or that that was argued in closing. It means the jury did not believe that I carried my burden, and it doesn't matter about that NGRI anymore, and they walk out of the court. If I do prove my case, they fail to prove theirs, and they don't think that that NGRI, has happened, then it becomes a normal criminal case, and they are sentenced under the normal sentencing ranges. If the jury does believe in an NGRI, that's the other piece that we're talking about. It's kind of a cliff everybody walks off of, because there is not much there to address this. So what you've done is you've proven to a jury that this has happened, that this is the harm that has been caused. It has been proven that during that time, that there are reasons why they were not responsible in that moment, or a lesser degree of responsibility in that moment. And then what happens at the end of it? It can be extremely tragic in all directions about, someone coming back to baseline and then they understand what they've done. And if you truly believe in the NGRI and do all those things, then what they're saying is, in that moment, I wasn't responsible for what I did, but I still did it. And it's important to understand, well, how do you remedy that? And I thought that was a really great philosophical question that you brought up earlier with Jared about, well, what makes these cases different than an originally sentencing one? In my mind, this is where it is. If you have somebody who, they kill their spouse's lover, you know why they did what they did. They know why they did what they did. There is a definitive punishment for that, saying that, I know you know that this was wrong, you did it anyway, this is where this was. I'm comfortable in the community that I don't think this is going to replicate itself again in quite the same way. If it is, it's your own choice and you've done this, but I can identify what happened and I can identify the risk to the public in the same way. It is very unclear in NGRIs why someone might have done what they've done and how we can make sure that they don't replicate that again. Because it can be someone simply walking down the street and hearing something, and that triggers something within the disordered mind, and they then react to it. I can't help them make a different choice if I'm not sure what happened in that sense. So when we're talking about why is that funneled into a different thing, it's because the normal timeout in corrections, if that's the most simplest way you talk about what that is or that behavior, it's not going to work in the same way because it didn't happen in the same way. Those factors aren't there. So if we have a dedicated facility which can address those underlying reasons of why, it helps make sure that they've got a baseline for that they've come back in a way that they understand what happened, but they understand a way that if they take their medication or if they see these things differently or something else is going on, that they don't have the same risk of thinking of that in the wrong way. And it helps them get on track to live a life that is better for them. And it also protects the community, saying I don't know why they were walking down the street and this triggered it, but I can tell you that we've had these professionals looking at this. They've dedicated time for this. They know this person. And these are the things and the supportive measures that we have to make sure that they're safe and that everyone else is safe. So that's kind of in that stage.
Well, if I can just follow up with that, just, so that's where it's, not guilty by reason of insanity, but what about the person who was found incompetent to stand trial and they've been found to be not restorable and they're being held because of the public safety risk? So that's a little different animal in that case.
It can be a little different. I think it becomes a little bit of a grayer measure as we're talking about stealing from a store versus somebody who has killed somebody. Where you're talking about,
But they haven't been adjudicated.
no, but they haven't been adjudicated, but they've been accused, right? So there is something that's happened and there's been a filing saying, we believe that this is what's happening. You can, there's a process that we need to do before we get to another space in that. But here you have, it's so low that whatever is happening, we need to make sure that you can access and engage with that process in that way. Because it'll always stay out there, right? You have a homicide which has no statute of limitations. That is forever going to be on there. There is a real reason to make sure that that is being allowed to happen. When you're talking about the restorability piece, which is kind of a question mark about, well, what does that actually mean, right? Does it mean forever? Does it mean, I don't think this person can be restored in the next 6 months? Or does that mean, I don't think this person can be restored in the next year or 2 years? It's unclear, and I'll be interested to hear what mental health thinks or other professionals about what that term actually means. Do they mean forever? And what does that look like? And is there a different, how long do we do this? What does that look like? Is there different ways to address it? But I do agree that it's an unknown concept about what restorability means or for how long that is. I don't know.
So, I mean, and I've mentioned, I forgot to ask Jared to comment on this, but something I mentioned yesterday is the situation where somebody's not restorable and they are a danger to the public, they can be held in perpetuity, right, under this bill. I mean, is that problematic?
I think it can be. I think it's really taking a look at what does it look like, right? Like, and because we're talking about such a small subset of these cases, I don't think it's right for the whole classification of it. But I think when you're talking about life offenses, you're talking about homicides. If this is something that happened and this person has been accused of it, then how long do we wait to make sure that they can engage in that process? And while engaging in that process, again, while we don't know why they did what they did, we don't know if they can make a different decision. How is the public protected or them from doing this again and having something else happen that we haven't addressed it or put in a support service that can address it? What that looks like, I don't know. And if it's a certain kind of setting or, what that is, I think the alternative to that seems much more terrifying for both the defendant and the public than coming up with some kind of mechanism where it's palatable and safe for everyone. I don't know at what time those things would change or if there's any other alternatives out there for what that looks like. So that's basically what I have. I'm happy to answer any questions.
Yeah,
We are fully in support of it.
Anybody besides my list of questions? I'll jump into a couple then. So, so what is your experience as far as individuals who are being held without bail currently who have been found to be incompetent? We talked a little bit with Jared about that as far as how long they might be held after a final competence or incompetent finding. And there's eventually a due process issue. Any further comment on that?
No, I mean, it really is. It depends. There was this really interesting joke that the first day of law school, everyone's kind of in this big auditorium, and the dean came out and he's like, you get here first day and you ask a question, a legal question, and everyone's like, I don't I don't know, no. He's like, by the end of 3 years, I'm gonna come back, I'm gonna ask you a legal question. With confidence, you're gonna say, it depends. That's kind of where it is. It depends, right? It depends on how long it is, what the legal maneuvering has been, what the outcome looks like. Again, I think, if it's years and years and years, yes, there's something to be said about it being reviewed. What I found in those kinds of cases is these aren't sleeping cases. They are cases that are in front of the court a lot. Nobody's forgetting about them. Everyone's concerned about what's going on, and what can be done in those cases is being done in those cases. I think the greater risk or fear is, like we're saying, in some of those other descending cases, which we're not talking about, what does that look like, right? Like where the forgotten nooks and crannies of things where there aren't, that kind of oversight. I think with the cases that we have now that kind of fall into that category of what that might look like, everyone is at the table trying to figure out the best way to move forward always. And we are lucky that we don't have any of those that are just, I feel, hanging out there or not being addressed or not being treated in the way that it should be, with all parties, defense attorneys, judiciary, prosecution, and any of their support services with medical or mental health. So I think we are small enough to be lucky enough that we don't have those cracks that we fall into. But I know that's not the experience of a lot of the country.
So what is do you have any concerns with respect to Department of Corrections being the entity that is going to be in charge of the forensic facility?
I don't, as long as they hire the people that they need to hire that are the right professionals to do this job. I think what we're asking them to do right now, they don't do. We do know that they do have certain levels of care for mental health illnesses that happen at one particular facility, and that DMH works very closely when those needs are exceeded, and that's transferred over. Same thing with any other medical issue that happens that then would not be, from Berlin, or would just be a normal medical hospital. I think you just need to hire the right people with the right qualifications in order to enact something like this. I do trust DOC to house those things, to be a part of that, and to be the place where that happens. What that looks like and kind of who those pieces are, I don't have any. That's not my job, but.
Yeah, understood. So I guess the other thing is I'd like to consider potentially adding aggravated assault and aggravated domestic assault in addition to life, the offenses that carry a life sentence. Any viewpoint on that, and how much would that change the volume of people as far, unless, well, that's a question I will generally have for people if we're considering something like that.
I'm not sure what the volume is, but I certainly wouldn't push back inclusion of crimes within this, because like I said, I think it's a disadvantage to all defendants that find themselves not competent. But when you're looking at crimes that have the biggest harm attached to them, or the biggest risks in terms of that to public safety, I think there is a number of other felonies that should, could be part of that conversation. I know that it was kept to be very specific so that we could take a tiny step in the direction before kind of bringing other crimes in, but I don't think you're off the mark at all.
Other questions for the mayor? Yes, Angela.
I asked this question earlier today, and I'm just curious to hear your thoughts. And I think Attorney Bianchi said he would have some language that might clarify, but I didn't get to, when we went through it, I didn't spot it, but I wonder, knowing that you worked on that language too, I'm having a hard time understanding how, in the case of a person who is deemed not restorable and therefore released from the facility, how realistic is the expectation that they will first understand the conditions or the orders under which they are released and then be able to follow them. Like, I just don't, I'm not, again, I don't have a full understanding of the scope of conditions we're talking about here and what would be deemed not unrestorable. But I'm just having a hard time understanding this.
Me too. So again, you're not off, but kind of what we're tackling. And I do think the edits will help clarify or at least focus the conversation in a way that I think might be easier. I do think that restorability is the question mark, because we don't have anything like it right now, right? It doesn't, what does that look like? What's the standard there? What does that mean? Like I said, does it mean within 6 months? Does it mean within this? Does it mean that what it would take to restore this person, we don't have that at this facility and we might need something else to do that? Like, what does that look like? It is unclear. And so that's what would be interesting to hear from DNH or other professionals from their understanding, or people who do competency restoration as their professional. What does that look like to them and what does that mean? Because I do think it's in there as a concept, but on a granular level, I still think it's something to be discussed, what that looks like and what that means.
Okay, yeah, that makes sense.
Any questions for all right, not seeing any, we'll probably have you in for the next version as we look closely at the recommendations from Jared. And you said that you've been working with.
Yes, so I talked with Jared too. So and we support the edits that.
Okay, good. All right. Thank you very much.
Thank you very much. Enjoy your day today.
Yes. So we'll turn to Judge Zone, who's joining us on Zoom.
Good afternoon.
Thank you for your flexibility. Thank you for being here, Judge.
My pleasure. Tom Zone, Chief Superior Judge. I listened to a few of the questions, and I think they give rise to my initial comments, which are that this bill is something that contains a lot of policy, a lot of decisions for the legislature. There will very likely be challenges to aspects of it if it's adopted, as you've identified, due process and other types of provisions. And so I think I'm quite limited in how much I really want to get into this. There's some language issues and things I've noted, a few little points, but I don't want to go down the road of saying, well, you need to do X, Y, and Z, because I think once I start doing that, it can look like I'm giving opinions on the policy, and I don't want to do that. So if it's okay, I'll just hit a few of what I'll call, if you're going to go with this policy, looking at the as-passed version, just a few comments, if that works.
Yeah, no, that's great. Just any kind of red flags you see or clarifications that would help the court on applying this would be great.
That was my goal. So on page 1, line 8, it says a person shall be transferred to the forensic facility. The word transfer is not a word that necessarily would work in all circumstances. For instance, if someone happened to be out on conditions of release, they're not being transferred. What we generally would look at is placing someone in the custody of someone else, of another entity. And so it may want to consider a person shall be placed in the care and custody of the Commissioner of the Department of Corrections and remanded to the forensic facility, something like that. That's the type of language that we would generally see when we're placing someone in custody. On page 2, lines 6 through 14, it's subsection 2A. It talks about a second or subsequent evaluation. And then on line 8, it says, if the court finds that the person may be found likely competent to stand trial, the court shall immediately notify the state's attorney and the person's counsel. That doesn't make a lot of sense, because it almost appears that the court is making some type of finding outside of a court process. So I'm not sure what that means, but I do know it doesn't really work well.
Yeah, no, we definitely flagged that, and we have some proposed language already from the state's attorney or Department of State's attorney to clarify that bit. So,
all right, if you go to line 21 at the bottom of page 2. It talks about has certified as appropriate and then the court has found to be appropriate, but we don't have any standards to apply. What makes it appropriate for the court to make that finding? Likewise, if you go to page 3 on line 3, in this section, it's talking about conditions of release, and it says with any other conditions appropriate to protect the public. It's unclear whether or not that is in some way supposed to completely remove 13 VSA 7554, which are the conditions of release statute that we have to apply, or whether we do, or whether the appropriate conditions have to fall under that. In other words, is this intending to completely change the factors that we have to consider and the conditions that we can impose that the legislature has enacted under 7554? That's unclear.
Yeah, question. Go ahead.
Judge, didn't we have these in place years ago when we had the Waterbury facility already operating?
Well,
The last two that you brought up, I'm sorry.
well, the language that is here is new, and I don't recall what was around Waterbury back in 2011 in terms of conditions. But if this language had been brought to me in 2011, I think was when Waterbury closed after Irene, right?
Right.
If this had been brought to me back then, I would have been saying the same thing, even if it would have been brought to me before Waterbury closed, because it gives rise to a question as to whether or not 7554, which we do have and have had a long time, still applies, or if this somehow is intended to give us something that is much broader.
Okay, thank you.
On page 5, at the very bottom, section 2 from lines 10 through 20 talks about dismissal and when dismissal of misdemeanors is required. It's unclear whether this is intended to say the court can or can't dismiss for other authority. There's Rule 48, there's other provisions that the court has the authority to dismiss under, and constitutional provisions, of course. And so it may be appropriate to add at the very end of line 20, after the word justice, a new sentence that says, nothing in this subsection shall limit the court's discretion to dismiss a charge under any other authority.
Yeah. Can you say that again real quickly?
Certainly. Nothing in this subsection shall limit the court's discretion to dismiss a charge under any other authority. And that, again, would just make it clear that this is not trying to usurp any other statute, rule, or constitutional protection. On page 6, this is the section under section 3 that talks about individuals who have been found not guilty only by reason of insanity. It talks about a forensic risk assessment. And it also references within the language of B2 from lines 13 through 20, it talks about the examiner, but it's not clear who the examiner is or what their qualifications need to be. And so is it someone who is under section 4814 of Title 13, that's a psychiatrist or a doctoral level a doctoral level psychologist trained in forensic psychology and licensed? So it's unclear what the criteria, what the qualifications of the examiner are.
Karen has a question.
Judge, sorry, it's going back to section 2. I was catching up, yes. And I don't know exactly what my question is. Maybe this has already been covered, but I made a note of this. So this is page 5, line 17. it says the case remains inactive for a continuous period. Is it clear to you what inactive means or how that's defined?
Generally, it would be from the date of the finding of incompetency that we know we're not able to go forward.
So inactive, the time period, is there a set time period or just inactive for?
It's for the length of the.
When that happens, it goes, actually, I take that back. It may actually be the inactive because we still have to be active in order to do the hospitalization hearing and those proceedings. So I think that's the date on which it goes inactive, which is at the hospitalization time.
So the way this works, that language, is it's not from the time of the charge. If they find after a year or whatever that the person is incompetent to stand trial, the 2 year, if it's a 2 year misdemeanor, would start on that date, not from when it was charged.
That's my understanding, but I will get confirmation about when we put it in the inactive status.
Yeah, okay.
And that makes sense.
Does that make sense? Should it be from the time they were charged?
If competency is an ever evolving thing,
So it gives it does give it a set period.
and it gives you
Year
some
plus.
time that competency could be.
Right. And importantly, Judge Zoney, am I correct in understanding what you just said, that putting a case in inactive status is something that happens?
Yes.
Like that's
Yes,
the thing.
this is the issue that when you look at dismissal, it seems that the policy is trying to address, and that is you have individuals who are found to be not competent. In some counties, the state's attorneys will dismiss the matter at that time, and the case after the order of hospitalization, they'll dismiss the criminal action. In some counties, they will not. In some counties, they have a mix depending on the charge itself and whether the state's attorney believes the person may at some point regain competency. But we do have this category, and the cases will stay in that category unless and until they're dismissed or until there's a motion to dismiss. And that's why I mentioned that language at the end of the section, because there are times you'll see a motion where someone is requesting the case be dismissed based upon constitutional or other bases.
Thank you.
On page 9, line 7, we're still in the section for not guilty only by reason of insanity. And it says that one of the things that can happen is order as an explicit condition of release. If someone's found not guilty by reason of insanity, their case is over. There's no more conditions of release. There is the statutes under Title 13 do currently provide for how we address it, and that's with the hospitalization hearing and going forward like that. But as far as conditions of release, once someone's acquitted, not guilty by reason of insanity, again, the case is over. But for the mental health aspect that we're addressing. And
So before you go on that one seems to be pretty major. As far as so. Well, I can't. I will have to talk to our lawyers. I can't ask you for your viewpoints constitutionally on how we can create or keep a case alive after the acquittal, if they need some sort of court oversight, short of going through the order of hospitalization or non-hospitalization.
I leave open that you may hear from witnesses who say that it's okay and there's a view there, and then the court would have to address it. But I would say that, again, my initial reaction is conditions of release are until the time of trial. When someone is found not guilty at a criminal trial, they, as Mr. Goodnow knows, they turn around and walk out, and their conditions are no longer in effect. That's the common approach. I would also note that here it talks about, again, any other conditions appropriate to protect the public. So even if the first section, that first half is okay, we're still into that 7554 question about, does it have to be in accord with that? And that's going to be a determination for the courts.
So maybe this is way off type question, but I'll ask it anyway. So if there is an order of non-hospitalization, can conditions be attached to an order of non-hospitalization?
There are statutes, I believe, that provide conditions can still be out there, and that if you look earlier in the statute here in this bill too, there was the language about, the court would impose conditions. The practical aspect there, certainly what we find is if there's conditions on someone who's been found incompetent and they violate the conditions, they come back into court, and oftentimes we're just repeating exactly what we've done the first time, where they're again found incompetent, and it follows
Right.
itself.
So yeah, in the competency area, certainly, but if there's, so orders of non-hospitalization don't have any conditions on them, or, I mean, or
Orders of non-hospitalization should address the treatment aspect.
right.
We've actually had Department of Mental Health there's been comments, I don't mean that in a negative way, but we've received information that there's concerns at times, I believe, that judges could be putting in conditions of release type conditions into orders of non-hospitalization, when the purpose of an order of non-hospitalization is not to serve as you shall not go to Cumberland Farms type conditions, but
Right.
instead you shall take your medication as directed.
Right.
So treatment as opposed to public protection for matters outside of treatment.
Right, and that's the kind of treatment, or that's the kind of conditions are talked about on that page 9, or not like a stay away order, those kind of things. All right, just trying to puzzle out this.
Page 9 actually has two types. Under the first section, lines 3 through 6, those are the ones that I would say are the treatment related. Lines 7 through 9 are the ones that come out conditions of release side of the equation for the public protection.
Right. Now, Angela.
Am I understanding this correctly? That I think I just heard you say that in cases where a person is found not guilty by reason of insanity, that finding effectively ends the case and ends the court's jurisdiction over that person.
No, it does not end their jurisdiction over that person. What it does is it addresses the criminal liability, and the legislature has enacted statutes that when someone is found not guilty by reason of insanity, jump down. For instance, what next happens, the court before which person is to be tried shall hold a hearing to determine whether they should be committed to the Commissioner of Mental Health or Commissioner of Disabilities, Aging, and Independent Living as appropriate. Such person may be confined in jail or some other suitable place for order of the court pending hearing for a period not to exceed 21 days. And so that's 13 VSA 4820. So when there's a not guilty by reason of insanity, they're acquitted. The criminal liability, if you will, is addressed. There's no more liability. You may have heard the phrase double jeopardy. So their double jeopardy is as attached. They're acquitted. And what then happens is the statutes that address how we move forward with someone who has been found not guilty by reason of insanity, they come into play.
Okay, and the two options are placed in the custody or under the supervision of jail or DMH.
Currently, that's correct.
And this bill proposes to effectively place them in the custody or under the supervision of the Department of Corrections.
This changes, yes, this changes things for certain cases. The life imprisonment, in other words, this.
Yeah.
What I said a moments ago from section 4820, that applies to everyone right now. And so this new bill would say in these cases, we're going in a different direction for these individuals, correct?
Okay. We need to make that change somewhere, right?
We probably need to change 4820
4820.
and somehow extend the jurisdiction of the court.
Yeah. It seems like we'd be missing a bridge if we didn't do that. Okay, thank you.
Karen.
And just see if I'm getting, it's because this is condition of release from a forensic facility. And we don't have a forensic facility, so we don't have any conditions of release from a forensic facility.
I read this to be conditions of release in the underlying court case.
Oh, see, I read it from forensic facility. And that's where I would see it as, okay, so we don't have that established yet, but I guess that's for clarification.
Yes, when you say that, I think to myself, that makes sense. I understand that. And that's a reason why it should be clarified, because when I hear the phrase conditions of release, I think of ordered into court under 7554.
Yes.
And regardless, we'd have to, it sounds like we still have to create the bridge to get them into the forensic facility.
Yeah, to make it clear that
Yeah.
this trumps that, if you will.
Yeah.
Yeah.
In the last section I had, it was just a comment. There is a provision here. Knowing your work on H744, I would be remiss if I did not point out that on page 15, there is a change to the Vermont Rules of Evidence.
Yeah.
And I take no issue on that. In other words, not saying yay, not saying nay. The legislature has the right to make those changes. Essentially, what the change does is it adds a provision to the Vermont Rules of Evidence that says that these proceedings for competency restoration or granting conditional release from a forensic facility are the rules of evidence do not apply. And so that's a legislative determination. It does, just for future information, and the committees may have considered this, but it doesn't have to be in the rules of evidence. The legislature does not have to actually go in and change a rule of evidence to make this type of provision, because under section 1101 of the rules of evidence, B6, there's a catch-all that says the rules don't apply if there's a statute that says they don't. So the legislature could actually still accomplish the same thing by doing a statute and saying the rules of evidence don't apply, putting it somewhere in the other sections. But the fact that it's here, I have no objection. That's certainly a legislative policy determination that we will move forward on. And that's all I have.
Any other questions for Judge Zone? Yeah, Sam.
I do want to ask the same question I've been asking, and you kind of mentioned it in passing about this. You described what I was imagining might happen, which is kind of a cyclical situation with someone being released, someone who's not competent, can't be restored, released with conditions, ostensibly doesn't, maybe lacks the capacity to understand the conditions, violates the conditions, comes back before the judge, is found to violate, goes back to the forensic facility. Like how is this not just a repeating pattern? I'm having a hard time understanding how I can imagine there would have to be very labor intensive oversight potentially. And maybe that would just be with a couple of cases. And so it's not worth pursuing any further than I have by asking of every witness the same question. But I just don't see how this works.
I can tell you that there are currently cases, and I have certain cases in mind that I have had where you have an individual where what you just described does occur. There's a finding of non-competence after a number of charges, finding of incompetency, and what then occurs after that is they have conditions of release that have been on, and even though you just found them incompetent, another charge comes in, and another charge, and so that is something which it does occur. And oftentimes it relies on the discretion of the state's attorney to determine whether they're going to go forward and order another competency evaluation or how they're going to handle it. And so while I recognize that there's the potential for that to occur, the level of it and the impact of it, I really can't say. And also I would note that when these types of events happen, there's questions that are raised and there's filings that are made at times from the attorneys challenging those next cases. And so that's not an area that I should really make any opinions, offer any
Sure.
opinions on.
Yeah, okay. But fair to say that you have seen that scenario play out.
Seen cases where individuals have repeated competency issues and charges keep coming in, and the court, I would say, they were just found incompetent. Is there something else we can do here? And it just another charge.
Yeah, is there any process you've seen or anything we could look at that would like check for understanding when, upon issuing the orders of release, or, I don't know. There's nothing existing that like double checks that the person who's supposed to follow these conditions understands the conditions, right?
When a court imposes conditions, it's always incumbent upon the court to seek to make sure that the individual understands them. But obviously, there's questions at times if someone does or does not. And I know that the attorneys, defense counsel certainly strives to make sure the clients understand the conditions to follow them.
Do you do that by asking, do you understand these conditions?
That's one method, yes.
Okay.
I think Barbara. Thank you, Barbara.
So I have a question, but it may be way off base, just because I was out yesterday. So if everybody who was found incompetent to stand trial is given a restoration order to start with, assuming they can be restored, then there would be conditions assigned with the restoration order, yes, or?
Well, when you say everybody who's found incompetent, only the individuals who qualify.
Right. Well,
and here, under this bill, on page 3, the top of it there talks about conditions being imposed to protect the public.
right. So I guess the question is, when we think someone cannot be restored, one, I'm not sure how and that's probably not a question for you of like, who is that and how often does that happen? But if we assumed, unless proven otherwise, our goal is to restore everybody. So that's our default. And then we move in that direction until there's more evidence that comes in that shows perhaps restoration cannot occur. I don't know. That still like punts the problem down the road, but I just wonder about that divide right off the bat of people that we're saying can't be restored and the case is over, right? Then the case is dismissed.
I think those types of questions really go more towards the policy side for DMH, Attorney General, State's attorneys, and Defender General to weigh in on. Because again, when we start looking at things going forward with this type of bill, we're going to be in the courts, we're going to be called upon to address, I would suspect, a number of different aspects of it.
Okay.
It's a policy question. All right, any other questions for Judge Zone? I don't see no. We will probably have another version of this, and we'll see if you want to weigh in on that. Once we get that, that'll probably be later next week, I would imagine. So, all right, thank you very much. So that's all the witnesses that we managed to get together for today. We still need to hear from Karen Barber from the Department of Mental Health. I was going to tentatively set that up for 1 o'clock on Friday, so we can get that out of the way, because we'll probably need her to come back in after we do this next version. But I have Jack McCullough, we have the Vermont Legal Aid, Disability Rights Vermont, the Defender General's office tomorrow, And we have the Vermont Developmental Disability Council on Friday morning. The other witnesses I'm considering bringing in would include Jen Pullman, Joanne. Don't know if I got the spelling right yet, but it was somebody that Kelly Carroll mentioned, Cortendick, Jordan Sauter of ACLU, and Stuart Schur of Dale. Anybody else that you can think of meeting in this first pass? But again, we're going to bring some of the same folks back in after we take a look at what Jared and Dominica have as their proposed amendments and some of the stuff we just heard from Judge Zoney. And anybody else? We have everybody, Rebecca, from your shop that needs to? Just Stuart, okay. Okay. And also, just Karen, do we need to hear from them? Yeah, and so I was thinking, I mean, there's like 3 witnesses that are really on the DOC part. I don't know that that's for us to hear, or if we just want to.
Can we hear a little bit from them?
I mean,
They're
so,
like in charge of the whole thing.
yeah, that's true, I suppose, you know. That's not as much our jurisdiction, but I guess, you know, knowing that hurt. So that would be, we have the general counsel from the Department of Corrections, John Murad. And then there's an individual from WellPath, Robin Hodges.
What about?
Hearing,
Yeah, I know. That sounds like a plan. Oh, what?
joint hearing.
I can find out from Alice what, yeah, that might make sense. That might make sense.
And
Yeah, that does make sense, actually. But they got to hear our part, so we get to hear.
Yeah. And someone from BGS, maybe?
Yeah, Wanda Manoli, that also seemed to not necessarily be us. I'm not sure if
Right.
that's healthcare or human services, that they're still in the loop. We haven't. They come in.
Well, institutions.
There was a backup material today from Robin Joy, like a criminal life offenses.
Yeah.
I'm not sure which witness that was for, but I'm just wondering, do you want to call Robin?
Do we need to talk to Robin? I mean, that was just, I wanted to get that data, which is, it's online right now, everybody. It tells you how many offenses. It's really, yeah, it's the offenses and also the maximum penalty, the total charges. This is between, well, it doesn't say what the date is, but I had that.
It's 2017 it's in the title.
Oh, okay, yeah.
2017 to 2025. Interesting note, 13 VSA 3484 is still punishable by death.
Yeah, no, I saw, yeah. So, Adriana tried to get rid of all the death penalty last time. He apparently missed one. We'll have to talk about that.
Is there anyone we could talk to about who actually has run one of these, or like from a state that has a forensic facility, and just like how it works ideally, and if we are anywhere close to that with this bill?
Do you folks have any contacts? Claire, that you can-
Provide this in other states. So
Okay,
based
well,
on
yeah,
that,
that's good. Yeah, all right. So we'll see if that's going to be a joint here. And if not, we'll bring them in here as well. Let me see if there was anything else on that. So my suggestion is that we get the input from Jared and put that in addition to a couple things from Judge Zoney. And after we hear from the rest of the witness, Karen, Barbara, and the other folks the rest of the week, we'll have another version to look at like next Thursday. I'll set up witnesses for next Thursday to come back in and look at that. Does that sound good?
Meaning we'll keep working with this.
We're
draft.
going to keep working on this
Yeah.
draft until we have heard from all the first pass of all the paid witnesses. So, all right, well, good. So we are then adjourned